Hello everyone, my name is Zhang Yue. I'll presenting the introduction. Protecting child and young workers is both a legal duty and a moral obligation. Children are especially vulnerable in the workplace due to their physical and mental immaturity, often facing unsafe conditions that harm their long-term development. Malaysia has signed the UNCRC and adopted the ILO standards. However, a significant gap remains between the law and reality. Poverty and limited access to education are the main drivers of child labor. Undocumented refugee children are left without effective protection. So the objective is examine the current legislation, identify where enforcement is falling, and propose concerned recommendation for the reform. Next, I'll pass to Shah for the little review part.
So based on the literature review, there are two key issues. First, poverty is a major factor that contributes to a child labor. So while the Malaysian law is actually allowed children to perform the light work, and excessive work may affect their educations. So therefore, a balance is needed between the academic needs and the children's educational rights. Second, enforcing child labor law remains challenging. So many migrants and undocumented children that work in informal sector that are difficult for authorities to monitor. Reports by Suhakam and also the ILO also highlight the risk of exploitations and forced labor among migrant children. So there are three important cases. First, the public prosecutor versus law saying established that children welfare should be prioritized over the employment agreements. Second, we have the Madisa versus Syarikat Jaya Seberang that employees have a higher duty of care towards their young workers. Third, we have the Hong Kiangan versus Law Sam and Sons introduced the degree of control test to determine whether a worker is an employee and therefore entitled to legal protections. So however, as overall, these cases show that Malaysian court prioritize the safety, welfare and also the rights of the young workers.
Thank you, Shah. So hi and good day to everyone. I am Sarah. I will now present the related legislation governing child and young workers in Malaysia. The two main laws are the Children and Young Persons Employment Act 1966 and the Employment Act 1955. These laws aim to protect children from exploitation while allowing limited employment opportunities that support skill development without affecting their education and welfare. Under the Children and Young Persons Employment Act, children aged 13 to 15 are allowed to perform only light work that is safe and does not interfere with their schooling. Young person aged 15 to 18 may work in sectors such as shops, offices, factories, and agriculture, provided that the work is not hazardous. The Act also prohibits children and young persons from engaging in dangerous occupations, including underground mining, operating dangerous machinery, handling toxic chemicals, and work related to prostitution or gambling. In addition, strict working hours limits are imposed. For example, children cannot work more than 6 hours a day or during the night, and they must receive adequate rest breaks. Although these laws provide a strong legal framework, there are still challenges. Loopholes, weak enforcement in informal sectors, and poverty continue to contribute to child labor. Therefore, stronger labor inspections and continuous legal reforms are necessary to ensure that children are fully protected. So now I will pass to Afika and Aisha. Thank you.
Assalamualaikum, my name is Aisha Nataya Isa. So now we'll be moving on to the role of industry court. So the industry court plays an important role in protecting workers' rights and ensuring access to justice. So in Hong Kiangan versus Mahkamah Perusahaan Malaysia and UNOR in 1996, the court recognized the Industry Relations Act as a beneficial social legislation. The court emphasized that workman status should be determined based on the actual employment relationship rather than job titles, which ensure that vulnerable workers are not denied legal protection. So, similarly, in Buyon Lian versus Beng Sing Corners in 2021, the court applied the control test by examining factors such as employer supervision, duties performed, and also remuneration received. So this approach helps prevent employers from avoiding their legal obligations through contractual labours and ensures that workers receive protection they deserve. Okay, so now we're moving on to the contractual validity, where here the case example focuses on the validity of contracts involving minors. So under Section 11 of Contract Act 1950, minors generally do not have the legal capacity to enter the contracts. So this principle was established in Mohori YB versus Tarmoda Schools in 1903, and then later it was reaffirmed in Government of Malaysia versus Kucharan Singh and Ors in 1971. So however, the Children and Young Persons Employment Act 1966 provides an exception by allowing certain forms of employment for minors subject to specific conditions. Therefore, Malaysian law balances the need to protect minors from harmful contractual obligations whilst allowing lawful employment opportunities that benefit their welfare and also development. So next, I'll be passing it to Afika.
So next, I will discuss the recent trends in child labour protection in Malaysia. First, the Children and Young Person Employment Amendment Act 2019 strengthened legal protection for children and young workers. The amendment expanded safeguards for children workers, clearly defined what constitutes permissible light work, and prohibited children from engaging in hazardous occupation. Secondly, the Employment Amendment Act 2022, which came into effect in 2023, introduced stricter enforcement measures. One significant change was the increase in the maximum penalty for labour law violation from RM10,000 to RM50,000 Malaysia. This demonstrates the government's stronger commitment to ensure compliance with labour standards and deterring unlawful employment practices. Lastly, the courts have also played an important role in protecting child welfare. Judicial decisions have emphasized that employees have both moral and legal responsibility to safeguard children's welfare, education, and development. These rulings reinforce national efforts to reduce child labor and prevent exploitation. Overall, these developments reflect Malaysia's ongoing commitment to strengthen child labor protection through legal reforms, stricter enforcement, and judicial support. Despite having comprehensive child labour laws, Malaysia still faces several enforcement challenges. Firstly, child labour law in the informal sector is difficult to monitor and regulate because it often occurs in family businesses, street trading, and agricultural work. As a result, many cases remain undetected by the authorities. Secondly, enforcement efforts are limited by the shortage of labour inspectors, particularly in rural and remote areas where workplace inspections are conducted less frequently. This can allow violations to continue without detection. Finally, undocumented migrant children face additional vulnerabilities. Many are reluctant to report exploitation due to fear of deportation, while language and a lack of documentation make enforcement more difficult. Overall, these challenges highlight the need for stronger monitoring, greater enforcement resources, and better protection for vulnerable children to ensure that child labour laws are effectively implemented. Next, I'll pass on to Howard.
As for the recommendation, we have 3 recommendations stated in the report, which is the first one is enhancing the legal framework for child and young workers. First of all, we must clarify the definition of light work. What is light work? Light work is a non-hazardous work that does not affect education and development, and it must comply with the age and working hour limits. And how to enhance the legal framework is by aligning with the legislation of International Labour Organization Convention number 138. So the next one is by strengthening enforcement and compliance mechanism. How to strengthening enforcement? By increasing the number of labour inspectors, like conduct a regular and surprise workplace inspections that focus on high-risk sectors. What kind of high-risk sectors that we can do the surprise inspection is plantations, food services, and family-run businesses that always take young workers as their workers. So, and the last one is impose stricter penalties on employers. And we must impose stricter penalties on employers violating child and labour laws. As for the last recommendation, is by adopting international best practices for child labour protections. Like Malaysia has done, expanding financial and educational support for low-income families. Or other than that, Malaysia can benchmarking with our neighbouring country like Singapore and Thailand that regulate light work and prohibit of hazardous and exploitative work. By doing that, Malaysia can strengthen the child labour protection system and promote a safe working environment.
In conclusion, Malaysia has the law in place, but without stricter enforcement and stronger social support, true protection for child and young workers will remain out of reach. Every child deserves a childhood, every young worker deserves protection, and every employer has a responsibility to uphold both. That's all of us. Thank you.